heat. From the judge to the jury, everybody's on screen. We're from the Live Zoom court, you know what I mean. Boots on the floor, but the courtroom's online. Judge on the screen and the case is in line. From Texas to the world, we're watching it unfold. Every single hearing got a story to be told. Click that link, microphone on you. Everybody watching, trying to figure out the truth. Gavel hits hard, chat start going crazy. Courtroom gets quiet when the judge says maybe. Live Zoom court, everybody tune in from the courthouse screen. Let the proceedings begin. Judge on camera, gavel coming down. Case is going loud from every side of town. Live Zoom court, from the country to the city. Real courtroom moments and the chat gets gritty. Turn that volume up, let the whole world see. Live Zoom court, streaming justice digitally. Red light flashing, yeah, we're live on the scene. No courthouse hallway, just a computer screen. Attorney speaking, defendant standing by. Judge looks serious, everybody asking why. Country road, city streets, different courtroom doors. But when that gavel hits, everybody wants more. No Hollywood script, no movie set scene. Just real proceedings happen, live on the screen. Mic check, 1, 2, everybody locked in. Court starts now, let the hearing begin. Judge got the facts, attorney's got the case. Everybody watching every move and every face. From the Lone Star State, the courts worldwide. Different location, but the same legal right. Chat moving fast, notifications ring. When the judge says order, everybody does their thing. Live Zoom court, everybody tune in from the courthouse screen. Let the proceedings begin. Judge on camera, gavel.
So after court, we'll go into the jail to get your paperwork for the jail.
We are back with live Zoom court.
Why wasn't the city
Judge
probation, do we know?
Because
Papa,
they'll need to
Judge
confirm your
Papa.
employment.
You have one.
Indica su afección, proporcionando sobre upper secretariat
And on the 21st, the court will see if you're prepared to go into custody or if you're already set up.
Judge Papa here.
El 21 con más listo entre los casos o que necesita más tiempo para el 21 con más.
Just need your signature right there.
Mr. Lucas, just make sure Mr. Pablo Cruz knows that he doesn't want to come back in this courtroom on a probation violation, because we're going to do all the time.
Y entonces para ya pues ni usted ya en dejar en su alta corte porque a mí cada año vamos a tener.
Can't feed your family when you're sitting in jail.
Y que eso solo nunca con familia mientras toca los cárceles.
Thank you, sir.
Pues, right.
They are done over here at Papa's house. Papa's.
To the very best, Miss Cortez, okay?
Okay, thank you. Can I log off?
Yes.
Okay, thank you so much. Bye-bye.
All right. Isaiah Garcia.
Isaiah Garcia.
Yes, ma'am.
Hey there, how are you?
I'm good.
Good. So let's see. Okay. So it looks like, yeah, you just have some balances here. We've talked to you a few times. It looks like we were talking
Unpaid
about,
balances,
payment plan or
maybe.
community service, but we never heard from you. Do you want me to set you up with a payment plan or community service now?
The reason why y'all haven't heard from me was because I had did some jail time at the time, so that's why I couldn't get a hold
Oh,
of
jail
y'all.
time.
Oh,
Not the
okay.
good.
When were you in jail?
It was like a few months ago. I had got arrested for some public intoxications and
Oh, public
some other
intox.
things. Like
How long did you stay there?
at least like 2 weeks.
And it was here in Victoria County?
Yes, ma'am.
Okay. All right, hold tight. Let me get with the jail and figure out what went on. Hold tight, okay?
Yes, ma'am.
Oh.
Monica Rodriguez.
You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. And Mr. Kukuski, we can call your case.
Thank you, Your Honor.
People be Brittany Abbott, file 25-7088.
The 53rd Circuit Court here.
Mr. Goodrich, one kind of prosecutor.
Luke Kukuski, on behalf of Ms. Abbott, Your Honor.
Right, and I'm here for sentencing on a charge of evidence tampering. It's a 4-year
Oh,
statutory
evidence
maximum
tampering.
and a guideline range at 0 to 9 months. Mr. Kukuski, have you had a chance to review the pre-sentence report and recommendations with your client?
Your Honor, I have no additions or corrections to that report.
Okay, and any scoring challenges?
We did not have.
Ms. Goodrich, any additions, corrections, or scoring challenges from the people?
No, Your Honor.
All right, Mr. Kukuski, anything you want to say on your client's behalf?
Well, Your Honor, I'd just say that I believe Ms. Abbott's going to be successful on the term of delay, and the agreement that we've worked out with the prosecutor just really felt like a interesting case to me, in that she gets hired on, or is hired on for some firms that are collecting credit card debts, and she's to serve people. And there's not really much training as to how that service is to be done. I think she now understands the ramifications of what had happened. She has expressed to me she's very apologetic to the victims in this case, and sorry that if anything happened with their case, that she's sorry about that. But you know, she did. It wasn't that she just mailed it in, Your Honor, where she said she served somebody, but she didn't. She did drive down from Marquette, go to these residents, although somebody that.
We are going to
It is
small
3 o'clock,
claims with
2:59. It's time to begin our small claims matters.
small
We have
claims.
several errands, sales, and lease cases today, and we have a couple of discovery hearings. So let's see who's here. We have Madison 5, who's here for an asset discovery on Kelly Zablocki. I don't see Kelly Zablocki, so stick with me. Miss Madison 5, Madison Shelton. We have Rogelio from Aaron's Rent to Own. He's here on several cases.
Oh,
Is
damn.
Gail Thiel here?
Let's go back to this.
Serves, it's not the right person. So again, I think the disposition that's been worked out here is addresses the issues and addresses the conduct and behavior. I would ask the court to follow the agreement that we have for this 6-month delay with Ms. Abbott. This time, thank you.
Well, I mean, I wonder about those facts. She filed a proof of service with the court indicating that she had personally served the named people at an address and the location,
Oh, shit.
and included a description of the person, including, it said for one of them, described his appearance, including having a missing ear.
A missing ear.
So that sure sounds
the
like Ms.
hell?
Abbott is intentionally trying to say, yes, I personally served this named person when she didn't, and not just
What
some
the hell?
sort of technical mistake that she didn't know she could leave it with someone else at the household. So help me square that circle.
Well, Your Honor, there's an application with these firms that she's working with where you just check the box when the paper's delivered, they do the proof of service to the court, and that's the proof of service that was provided to the court. But she was not personally taking those to the court. Again, she accepts her responsibility for the improper service. We're definitely not making any excuses there. It just, what Your Honor.
But the proof of service is signed by her, right?
It would be electronically on her phone through the application with the company that she has. And so again,
Illegal papers were served.
as I've stated, you know, she's learned from this. She understands, leaving it with anybody that was not proper, but you know, it could have been where you leave, you just check the app that you did it, and you didn't even leave your home or come down to try to affect services. And she's accepted the responsibility by entering into this delay that she knows that it was not proper, and we're not making any excuses here, Your Honor.
Well, it sounds like you're saying she's not technically guilty of
I'm
intentionally
not at all,
tampering
Your
with
Honor.
evidence.
I'm not at all, Your Honor. I would not do that.
I mean,
I
just
wanted to-
making a mistake about what the court rule requires is a different thing entirely from felony tampering with evidence.
Well, and then I think the court is not hearing or is misunderstanding. I'm just trying to explain the circumstances or the facts around that, but I'm not making any excuses, Your Honor. I think it's important for the court to know the totality of those circumstances. That's all. Again,
So
we've,
the illegal
accepted the
papers.
Responsibility where
It's not
you
a
know,
good look on you,
got her
ma'am.
meeting with
Not a good
probation
look.
today. She's come down from Marquette. We're totally gonna
Not a
comply
good
with
look
the
on you,
delay
ma'am.
period.
Well, I'm wondering
Good
whether she should
candidate.
get a delay, honestly. So I'm wondering a process server that intentionally falsifies a proof of service with a court. That's what she's convicted of.
Yeah.
Somebody that does that, in my mind, ought to go to jail. So that's what I'm thinking about.
Your Honor, I don't believe this is the case that would warrant that. I definitely understand the court's concern. I do. But I'm not trying to make any excuse for the client. No.
All right, I can tell you, there's no way I'm doing a delay. All right, Ms. Abbott, you don't have to make a statement today. Is there anything you want to say or no?
Yes, I would like to sincerely apologize for being completely negligent.
See, okay, okay, hang on. You're not convicted of being negligent. Now, you pled no contest, so I can't force you to make a statement about this. But I'm not going to sit here and let you. You're convicted of intentionally tampering with evidence. You're not convicted of
Wow.
negligence. So let's start again.
I was incredibly naive and I did not understand how to do my job at all. I didn't understand how to be a process. So I just want to say something.
All right, Ms. Goodrich, any recommendations from the people?
Yes, Sharon, thank you. Here is stated, two victims had come forward on June 4th of 2025 to report perjury complaints stating that there was proof of service filed with the district court where they were not served. Fortunately, they both were able to prove that they were at work at the time. What's confusing about the explanation here today is that the explanation that the defendant is given is that she handed it to someone else, but that's not in the PSI description of the offense. And in fact, it says that neither of the people had cameras at their house to see if a process server was at their residence. So it'd be strange that nobody at their house would tell them, hey, I got this paperwork here today if somebody else was actually served. So I would guess that no person was served at either household based on those set of facts. The defendant is 36 years old. She has no prior felonies and one prior misdemeanor. Looks like she's part-time or sporadically employed and has a bachelor's degree. The guidelines are 0 to 9. the plea agreement was for the 6-month delay. The PSI accepts that.
People, man,
with a
fucking
focus,
people. I swear to God.
On services being for mental health treatment for the defendant, as well as using her positive family support system more so that she makes better decisions in the future.
All right, thank you. Ms. Abbott, if you please stand for the first sentence. All right, Ms. Abbott, I don't buy a thing you're selling me today.
Oh, shit.
You know, if what you're saying is true, at the end of what I'm going to tell you, you should withdraw your plea and go to trial and get acquitted. Because if what you're telling me is true, I don't know that that's a crime. Making a mistake at your job is not a crime. I probably did it today already.
Oh, shit.
You're convicted for certifying as a process server, certifying that someone was served personally when they weren't, and submitting something false to a court. That's
Damn.
a very serious crime. It's a terrible breach of trust. It undermines the legal system to the harm of litigants. You wouldn't like it today if I sentenced you and you weren't even here and didn't know about the case, because you're entitled to due process of law. The bare minimum of due process of law is notice and an opportunity to be heard. By your lies to a court, you
Lying to the
deprive
court.
one of your fellow
The
citizens
hell?
of notice and an opportunity to be heard. I think that's a pretty crummy thing.
It's a pretty shitty thing.
You have no prior felonies,
To do.
one prior misdemeanor. I don't really see a need for services on probation. It's really nothing that connects to this behavior of any like criminogenic needs, you know, that would have contributed to this situation. I certainly don't think that that kind of behavior warrants 6 months of a delayed sentence and a dismissal at the end. So again, either you're innocent and should go to trial, or if you're guilty, this would not be a just outcome. So it'd be my intention today to sentence you as follows. $68 in state costs.
Oh,
Crime victims
shit.
assessment, $130. Court costs of
Damn.
$350. Comply with DNA testing and pay a $60 fee.
Oh, fuck.
And serve 6 months in Sheboygan
Yeah.
County Jail with credit for 1 day previously served. That does not comply with that is within the advisory guidelines. I think even though it's an intermediate sanction, the circumstances of this crime, the breach of trust and the interference with the administration of justice are inadequately taken into account in the guidelines. So therefore, that does not comply with the sentence agreement. So you've got a choice to make, and I'll give you a minute to talk with your lawyer about that. You can either accept my sentence as I've announced it today, or you can withdraw your plea and it goes back to a pretrial posture, and we'll schedule the jury trial on 2 counts of obstruction of justice and 2 counts of evidence tampering. So I'll give you some time to talk with them. All right, and I had announced a sentence beyond the terms of a sentence agreement and given her some time to talk with you about her options. Do you know how she wishes to proceed?
Yeah, we would like to withdraw our plea at this time.
She's now
Okay,
withdrawing
Ms.
the
Abbott,
plea
your plea will be withdrawn.
and going to trial.
Bond will be continued, and we'll schedule this for a docket call for, and we'll have that docket call be a plea and motion cutoff, and we'll pick a firm trial date at that time. So let's, I mean, we could come back, I've got a docket next week on the 9th. We could just, gives you guys a couple of, a few days to see if there's anything
September
else that
9th.
you want to do, given what I've said here today. Or
When
if
is
you want to
that?
schedule it for
That's a
trial on the
Friday.
9th, we can do that. And Ms. Abbott can appear by Zoom for that, and you can too. That's no problem. You available next Tuesday?
Wednesday.
I'm not sure. I don't have a phone. My phone's operating right now, so.
Okay, well, let's schedule this for next Tuesday, June 9th.
It's a problem. I could let the.
Oh, June
court
9th.
prosecutor know.
That was a long
Yeah,
time
but
ago.
Don't wait for the mail. It's just next week. So I know the mail won't get to you. So next Tuesday, July 9th at 1:30, Miss Abbott, you can appear by video as you have previously. And we'll, at that date, schedule it for a trial if we need to.
Thank you.
Hold on. We come over here to small claims.
She's not here. She was personally served for this hearing. We had a default. Then she showed up, we didn't have proper service, and then we actually had a hearing. On December 1st of 2025. I found for the plaintiff in the amount of $2,500. In an attempt to collect on that, the plaintiff has had a subpoena personally served on Ms. Zablock. Let's take a look at that.
Judge
Something
Scheller.
going on in your gastric system.
And we are going
I
to
like
end
what
right
the
there on
prosecutor
Judge
said,
Scheller.
but then the defendant's testimony was that that article doesn't, you don't have to have had it. It shows, bypass it. It shows that it's physically possible to have a positive test without alcohol consumption. That the ETS concentrates in the urine in the article.
Y'all have a nice one. We'll be back later for Mikey on the Chase.